section 212 affidavit, and that is presupposed the compiler of such a report is not going to come before court. Now, if the compiler of that report comes before court, meaning when we put a dispute to the report, now that affidavit does not, it becomes academic.
No, that's why I said, can you leave that to the court?
As a concern.
Yes.
Thank you. Now, Doctor, this report, mainly the information you had obtained from Miss Meyer and her 4 kids, correct?
Including other 2 being Molen and Yasmin.
Yes. But none of the information contained in this report comes from the kids or Fatima's kids, the deceased children, correct?
Yes.
You said including who, ma'am?
Miss Molen, who's the house helper, and Yasmin, the mother-in-law to Mr. Rameez Patel.
Okay, yes. So no information was obtained from the other children, that is the children of the accused and the deceased.
Yes, my lord.
Now, Doctor, I want to refer you to paragraph 1.1. I'm on page 3. Where you refer to the last born and the youngest daughter of the accused, who is Razin. You say he dropped out of school in grade 5 or 6, he's not working and he's not married, correct?
The report says the last born and youngest brother, not daughter.
Sorry. I meant brother, sorry. I didn't mean to mislead you in any manner.
Yes.
I might have said daughter by mistake, Doctor.
Yes, sir.
Yes, so the brother, Razin, he dropped out of school in grade 5 or 6, he's not working and he's not married. What attempts did you make to get information from him?
The information I got from the family is, it is about 8 years being not in contact with each other.
In contact with?
With the family.
The family, you mean Nazrin? Or what do you mean?
The youngest brother of Rameez,
yes,
for a period of 8 years, he's not in contact with Rameez Patel's family. So they don't know how I could access him.
Now, yesterday morning, you consulted with the accused, correct?
Yes, I did.
As you consulted with the accused, and I know I'm alive, you said somewhere in your report that you should be able to amend this report if further information comes to light.
Yes, sir.
Now, as you consult with the accused, did you ask him about this brother in particular?
Yes, I did.
And what was the response?
The accused indicated that he has a brother who comes after him, who lives in the UK, and he is a medical doctor
Yes.
in the UK. He has a family and 2 children, and he has nothing to do with the family dynamics. And his younger brother, according to the accused, he hasn't seen him in 8 years.
And that was the accused that gives you
Yes.
that information.
Yes.
Just a minute, my lord. There's the court, please, my lord.
Okay.
You see, doctor, you may not be aware. Sometime in 2022, 2023, the accused wanted the brother to come and testify in this court. And from the information was that the brother was now staying with the accused at the time. Do you have any comment?
I didn't know.
So you cannot comment on that?
I cannot comment because I don't have knowledge about it.
Yes. And if it is true that around 2022, 2023, the accused was in contact with this brother, in particular Razin, it cannot be true that they haven't seen each other for over 8 years, correct?
Yes.
Thank you.
The question which my learned friend is putting to the doctor, psychologist, is incorrect. Because what was said was, and please bear with me, what was said, as I understand it, what the doctor said was approximately, that's how I understood the evidence, first, and then second, the accused has sent us a little note, and he says it was approximately 5 years and not approximately 8 years. So my objection is based on 2 grounds. Firstly, that I understood the learned doctor, the learned psychologist, to say that she was told, according to the notes, approximately 8 years, which would make it 7 years, 6 years, 9 years. That's approximately 8 years. Oftentimes when we plead in civil matters, we say on or about a particular date because the instruction received from the party is that they're not entirely sure, they haven't noted the actual date, but it's approximately that period, firstly. And then secondly, the accused has slipped us a note for what it's worth, and we must disclose this to the court in the interest of transparency, and his note reads approximately 5 years. Thank you, my lord.
With the greatest of respect, ma'am. Doctor, are you now amending your evidence to reflect 5 years,
Yes.
not 8 years?
Let me go back to my notes.
Yes, please.
Your Honor. I will go back to the original notes because this is where I was summarizing for the purpose of presenting in court if I'm requested to.
Yes.
Yes, I wrote it that on my notes. Younger brother, haven't seen him in 8 years.
Thank you.
To me, it's Between that period.
Yes.
Yes.
Period of 8 years.
Yes.
Yes.
Between 8 years or less.
Not up to 5. Is that what you are saying? Oh, Doctor, I'm asking up to 5, or even up to 2.
Looking at the agency of the interview we had, I believe he was estimating.
Yes. And the other person that they gave you that information, apart from the accused, was also estimating. Is that what you are saying?
My lord, there's no evidence from this witness that there was anyone else who had informed her.
Yes.
My lord, there's no evidence from the doctor that any other person furnished her with that 8-year period. In fact, the doctor gave evidence. It was approximately 8 years. And when my learned friend questioned her, she said, I gleaned this from the accused when I consulted with him. So my learned friend actually asked her, so you got this information from the accused? And she said, the doctor said, yes. Now my learned friend is talking about having obtained information from someone else. My learned friend has an active imagination. Perhaps he should clarify that with the doctor first, my lord.
No, I think she said
I
the
got this
family.
from a family.
Family.
That is what the
Family
doctor said, man.
informed her.
With the greatest of respect, my lord,
Before she talked about the accused.
I start to have a problem with my learned friend's interjections. Because I'm getting the impression that he now wants to answer the questions that must be answered by the doctor. The doctor said, I got the information from a family that it's 8 years. Now, post this report, the doctor went on to consult with the accused. The accused gave the doctor 8 years.
Yeah.
So now, it's the doctor that must clarify these issues, not my learned friend. Secondly, my lord, to show now it's becoming an issue, I don't want to say a trend, an issue that is repeating itself. The doctor says 8 years. Now my learned friend wants to give elasticity to the 8 years. He says, no, it's possible up to 5 years. That is not the evidence of the doctor.
That's fine, Mr. Mashiali. That's
Thank
fine,
you.
Mr. Khan.
Thank you.
Thank you. Let me take both of you. What's happening? You remember I asked you yesterday, Mr. Khan, if this witness is an expert witness. You said yes. You said yes.
Yes.
If she is an expert witness, she is more of my witness than yours. So she
That
is
I
actually
accept.
assisting the court.
That is correct.
So I would request both of you not to confuse this witness. Both of you. Let her say what she wants to say. And I can see from yesterday, she has been trying by all means to tell the truth. You remember I even tried to ask her a certain question. She managed to escape. And I even told her that she's very witty. I think somebody else would have just slipped and said something else. So can we make sure that this witness, I'm not saying leave her alone, just remember she's an expert witness. She's more of my witness than your witness. She might have been called by the defense, but she's more of the court's witness to assist the court than assisting any of you.
Your Lordship is entirely correct.
Yes, so let's treat her with, not with kids' gloves, but
With decorum.
with courtesy.
As your Lordship.
Please, I would request you do that. Thank you so much.
Thank you, madam. Doctor, I want to assure you of my utmost respect. And when I pose questions, please don't take it that I'm in any way disrespectful. I just
know.
want to understand the facts. I just want to understand your evidence.
That's what I understand, sir.
Thank you. I truly appreciate your understanding. And in any event, this information is what you were provided for. Correct?
Yes, sir.
Thank you.
But don't forget you're protected. If you feel you are uncomfortable, let me know.
Thank you, sir, Your Lordship.
Thank you.
Doctor, I want to quickly move to, let's move to page 4. You, on paragraph 2 there, where it says, with Rameez had established routine activities, you see that?
Yes, sir.
In fact, let me read the whole sentence. Rameez had established routine activities that created strong bond, security and an environment for both of them, that is Rameez and Rafaela, spending quality time together. You see that?
Yes, sir.
That's paragraph
2, madam.
paragraph 2.
On page 4.
Okay, it's not really marked. Starts with
Rameez had established,
Oh, okay. I see it. Yes.
and I just read that, the whole of that sentence. ma'am.
Yes.
But now, Doctor, I just want to, your comment, especially on sentence number 3, where it says they're spending quality time together. You see that?
Yes, sir.
Do you, and I take it, Doctor, you have been briefed about this matter. Not entirely everything, but you have been briefed what is involved in this matter, correct?
Before, if I get clarity, sir, before consulting with the family, you mean before?
The person that came to you the first time would have explained why we need this report.
Yes, she explained why.
She would have explained to you why the accused is in custody.
Yes, she
Thank
did.
And that the accused has been found guilty of having killed his wife.
Yes, she did.
So that information you knew.
Yes,
That the accused had, and the deceased had 3 kids together.
yes,
Thank
she informed me of that.
Thank you. Now, this,
By the way, Mr. Mashian, it's not paragraph 2. It's 1.2. Paragraph 1.2.
yes, 1.2, when it gets over to the 4th page, my lord, that's why I referred
Yeah,
it
yeah.
as paragraph 2 of page 4.
Yes.
Thank you. Am I correct, Doctor? The sentiment echoed in this paragraph is to the effect that particularly Rafaela misses the time he would spend with his dad, the accused, correct?
Yes, sir.
And I just want your comment, Doctor, if you were to factor in the accused biological kids that are now without the father because the accused is in custody, and the mother because the accused killed her. What would your comment be on this sentiment?
Okay. I want to go to my notes again because I have put it clear, and as I'm screening with my eyes, I will mention that the accused indicated that the close relationship with Rafaela comes because he's missing a lot with his biological children. He doesn't want the same thing to happen
With Rafaela?
with Rafael.
You just omitted to factor that in the report.
I couldn't factor it because the interview happened in court yesterday,
Oh,
just shortly before the court proceedings.
okay. Thank you, Doctor.
Yeah, what we could have done is immediately after reading your report, you could have supplemented it by saying that accused informed me about the following, so that we don't leave it out. But anyway, we are saying it under cross-examination now. I don't think it matters much as long as we get it.
Thank you. Doctor, I just want to apologize. I'll be taking you up and down in your report. The aim is not to confuse you. I want us to quickly go to page 40 of the report, because I think this is one of the other aspects we need to deal with now. You are, okay, let me start by saying this. At page 40, let's start with the very first paragraph, where it says a lengthy separation. Will you see that?
Yes.
And I want to go to the sentence in bold. You see that?
Yes, sir.
And you say there, Doctor, I recommend considering alternatives that prioritize family unity, in brackets, the likes of electronic monitoring, community service, house arrest, or home detention, probation or community supervision, close bracket, and support father's rehabilitation, ultimately benefiting the child's well-being. You see that?
Yeah, that's on page
40, ma'am.
40.
Yes.
That's recommend considering alternative. That's okay.
Yes.
Yes.
You see that paragraph, Doctor?
Yes, sir.
That will be your recommended sentencing option for this court, correct?
Yes.
You were made aware the accused killed his wife, correct?
Yes, sir.
You were made aware the accused the deceased left behind 3 young children, correct?
Yes, sir.
And yet you're recommending this sentence, community service, house arrest, home detention, and them. Now, does this, Doctor, address the scourge we are facing as a country, in your own opinion?
I was made aware the accused is accused of killing his deceased wife.
Yes.
Not.
Having been made aware of that.
No, she wanted to finish.
Oh, sorry.
Not what?
Not that he is guilty of killing Fatima.
Fatima is the wife.
Yes. I was made aware that he is accused of killing Fatima.
Okay.
Not that he killed Fatima.
Okay. Now that the court has made a finding that he indeed killed Fatima, will that affect your recommendation in any manner?
No.
So you're still of the view that this sentence will be appropriate, considering that he killed his wife?
Yes, sir.
Is that not giving a slap? Or is that not spitting on the faces of the many victims of GBV sketch?
I don't think I'm giving a slap on the GBV, looking at what I recommended as a method of rehabilitation.
Yes. Someone that killed his wife, you recommend house arrest?
I mentioned a few so that the state will be able to make a proper decision.
Yes,
on
but
that.
I'm asking you, doctor, based on what you mentioned. Someone that killed his wife, you recommend that he be given electronic monitoring and then be allowed to roam the streets.
When I made the recommendations, sir, I wasn't aware of the information that you just provided me with now.
Now, just 2 minutes ago, I gave you. Now that you are aware, does that affect your recommendation as you are standing here now?
I will have to do further investigation so that I can revisit my recommendations if it is necessary.
I'm alive that our judges aging, you need to assist with the cell phone.
Just put it for silence. I don't understand why some of the people also know that I'm in court. Put it for silence. See, common sense. Okay, thank you. You may proceed.
Thank you, madam. Doctor, I was saying, now that you are aware that the accused is guilty of having killed his wife, you still of the view that he be given electronic monitoring for him to be able to roam the streets, and you still feel that is the proper sentence?
I am of the view of being given time to do further investigation on this case and review my recommendations if it is necessary.
So these recommendations you made was because of the limited information you had?
Yes, sir.
Is that what you're saying?
Yes, sir.
But you would agree with me, given what we already know thus far, there is a serious flaw in the recommendation, in your recommendations for the sentence.
As indicated by you, I say yes, it is serious.
Thank you. You indicated yesterday that you testified a number of times in the courts. Correct?
Yes, sir.
I take it you are aware of the minimum sentence regime, the minimum sentence legislation, correct?
Yes, I have an idea. I can't say I'm clearly aware.
Well, you have an idea.
Yes.
That a person that is convicted of a premeditated murder, the legislation says he must be sentenced to life, correct?
Yes.
And
My lord, that is not entirely correct. The section reads, and my learned friend is being unfair to the word. Section 51, sub 1.
Has he finished, Mr. Khan?
Sorry, my lord.
Has he finished what
No, no, what is put to the witness is incorrect. Yes, it was.
what is it that was put to the witness?
What is
I
put to
said-
the witness is that.
Can you leave him to do it?
Yes.
And then you will respond later.
Yes, thank you.
I said the minimum sentence section prescribes that a person sentenced or convicted of a premeditated murder must be sentenced to life, and the witness confirmed. And then Mr. Khan stood up. Sorry, Advocate Khan, SC. Once again, I hear murmuring from.
My lord, that proposition which my learned friend has put to the witness is misleading. And I'll tell your Lordship why I say that.
Yes.
And I will read the relevant section so that we can put an end to this issue quickly. My Lord, Section 51, Sub 1 of the Criminal Law Amendment Act 105 of 1997 provides that a court subject to, and this is what I asked my learned friend to focus on, and this is where my learned friend is wrong in what he puts to the witness, subject to subsections 3 and 6 shall sentence a person it has convicted of an offence referred to in Part 1 of Schedule 2, e.g. premeditated murder, to life imprisonment. Judges may, however, in terms of Section 51 Sub 3, impose a sentence below the minimum if they find substantial and compelling circumstances exist therefore. So, my Lord, my learned friend should have put to this witness, look, this is what the prescribed minimum is, but it is subject to the Honourable Court imposing a lesser sentence should the court find that there are substantial and compelling circumstances which justify it. This is why the witness is here in court, to give evidence on those circumstances, that is, on those substantial and compelling circumstances. So that proposition which my learned friend put to the witness is misleading with submission, my Lord.
Yes, Mr.
I'm not withdrawing, my lord.
No, I never said you should withdraw. Did he say you should withdraw?
No, he says I'm misleading this court, and I'm not.
Ah, okay. That's fine. Let's proceed.
Thank you. Now, madam, you should be aware by now that the gender-based violence and femicide.
So you are leaving that
Section 51(1).
position as it is.
Oh, she answered in the affirmative, my lord. She said yes. She's aware. Now, doctor, you should be aware by now that as recently as November 2025, gender-based violence and femicide was classified as a national disaster by the president of the country, correct?
Yes.
And that should indicate that it's pandemic, it's a very big problem for the country, correct?
Yes, sir.
And it should be treated with brutality, necessary brutality, that we face it, correct?
I believe so.
And having said you believe so, even the sentences imposed by the courts should reflect that, correct?
Yes, sir.
The sentences imposed by the courts should send a clear message to the country, correct?
Yes, sir.
The sentences imposed by the court should reflect the cabinet stance on this GBVF, correct?
Yes, sir.
Thank you. I am done with that part of the sentence, Doctor, and we can go back to the report. Did you investigate the circumstances of Nazarene? Whether she's employed, what does she do for a living, and stuff?
We spoke about it during the clinical interview with her.
Yes. And what were your findings?
That she's involved as a housewife.
Yes.
Mm.
She has been attending this court a number of times. Let me rephrase it like this. How did she come to your offices? Was she driving? Did she take a taxi? Did she take a bus?
I'm not aware of that, sir, because I only found her seated at the reception area.
Yes.
And our parking is outside, so I don't know how she came.
Okay. From the information at your disposal, she will not be able to take a child to the doctor, correct?
No. I mean, that is not correct when I say no. The information I have about her taking the child to the doctor, she told me that the day I consulted with her, she said, yesterday I took Rafaela to the doctor.
Yes, thank you. That's what I wanted. Thank you, doctor. And she came by herself to your offices as well?
Like I indicated, sir, I'm not sure if she was dropped or she came driving. I found her and the house helper, Molen, and Raphael at the reception area.
She came in person to your
Yes.
office.
Mm.
Thank you. Let us move, Doctor, to paragraph 1.3 on page 5. And I want to just to refer you, Doctor, to sentence number 6 on page on page 5, paragraph 1.3, where it starts with intimate relationship. You see that?
Yes, sir.
Paragraph
1.3, my lord, on page 5. You say in the report, intimate relationship between Rameez and Nazarene only started 2 years after the passing of Fatima. You see that?
Yes, sir.
1.3.
Yes, sentence number 5.
Sentence number 5. Okay.
Proceed now.
Yes, we
Thank you. You see, Doctor, during the course of this trial, one Abdul Izak, the ex-husband of Nazarene, testified to the effect that the cause of the divorce between himself and Nazrin was that the accused and Nazrin were seeing each other, were dating, were in a love relationship. Do you have any comment?
I hear about it for the first time.
You didn't know about this?
I didn't know about this, sir.
Maybe just to complete this statement, Abdul Isaac and Nazrin divorced in 2015. Do you have any comment?
I don't know about it, sir.
Thank you. And I want to move quickly, Doctor. Let's move to page 7 of your report. And page 7 from my document starts, in the absence of Rameez. You see that?
Okay, yes, I am there.
And you say there, in the absence of Rameez, Rafaela is asking a lot about his father.
Can you clarify something? Because you are saying that I know the witness may not know about this. We have evidence that the accused and Nazrin were previously married.
No.
What is that?
Well, the evidence is that Nazrin was married to Abdul Isaac.
Okay.
And the accused was married to Fatima. The deceased.
Because then I would be worried that there are 4 children there. And how does the accused come in? If there are 4 children.
No, children are children. They are made any time.
Yeah. And then thereafter we deny them. Okay. Let's proceed.
Thank you, ma'am. Now, Doctor, I was on this sentence where you say, in the absence of Rameez, Rafaela is asking Lord about his father. He's asking everybody where he's dead. You see that?
Yes, sir.
And Rafaela is now 18 months old.
Yes, sir.
Will a continued professional intervention assist in this particular instance? Or will he, as he grow older, get to understand that daddy is not here, he's in prison?
If he receives play therapy, it will assist, and as he grow, he will gain insight into the family circumstances.
And will get to cope?
I believe so.
Thank you. Similarly, Doctor, on paragraph 3, I'm still on page 7. You see paragraph 3 where you say impact of separation.
Oh, yes, I am there.
Yes. I want us to start on line 3 there, where you say he experiences constipations and the doctor prescribed medication for him. Yesterday he consulted with the medical doctor who commented about him losing weight, mentioned that his immune system is compromised and prescribed multivitamins. Of late, he has high fever, constipation, and lack of appetite. This information you were told by Nazrin, correct?
Yes, sir.
Because you are not a medical doctor, you cannot tell whether this is the position or not. Correct?
Yes, sir.
Thank you. I want us, Doctor, to move to page 8. Where you say employment history of Rameez. You see that?
Yes, sir.
You say there, Doctor, Rameez is a self-employed businessman. He is into construction. Page 8, no?
Page 8.
Paragraph 4.
Yes.
You say, Doctor, there, Rameez is a self-employed businessman. He is into construction. He works from home. However, he used to go out on site for a few hours. He also overlooks family business in Venda as the firstborn son. You see that, Doctor?
Yes, I do.
And this information you were given by Nazareth?
Yes, sir.
And when you consult with the accused, I know you already had this report ready, but did you bring this information to the attention of the accused?
I didn't.
Sorry?
I didn't.
You did not.
Mm.
You see why I'm asking this question, Doctor? The accused made a bail application last week. And in the affidavit for the bail application, he stated the following on paragraph 6.8. And he says, save for my property development business in Venda, all my other assets, which include immovable properties, interest in commercial outlets, are situated in Polokwane. You hear this, Doctor? I know you were not here when that happens.
I heard you say.
And in fact, in the bail application, the accused submitted that he is a director of ZS Realty Pty Limited and Wapipi Property Pty Limited, and they are in his names as chief director, and that he personally supervises all the operations of the businesses. Now, at no stage did the accused tell us about these businesses in Venda. Do you have any comment?
My lord, I think my learned friend is misunderstanding the word construction. Construction means property development. I think therein lies the rub. That's construction, building houses, that's property development.
My lord, what I've just read to the doctor needs no interpretation. It states that he also overlooks family businesses in Venda as the firstborn child. It's written there. Now, just last week when the accused made bail application, he speaks of these properties, developments. Nothing about the family business is in Venda. Now, how difficult is it for the doctor to be able to say, I was not informed of that? Or if she was informed, no, on consultation with the accused, this is what I was informed.
Yeah, just a minute. You know, I'm busy with a very long trial elsewhere in this country. And the same thing is happening, The counsel for the state tries, because we're still busy with speeches, tries to answer questions for the witnesses. And I told him, no, you don't do that. You must let the witness answer the questions. And you still have time to re-examine. So that's when you raise all those things. So I think the same applies to you. You still have time to re-examine them. You can correct those things. Let's not correct the evidence of the witness as it goes on, unless he makes, for example, a serious legal error and he puts it to the witness. That's something else. But with the other factual issues, you can easily correct them. I mean, when you re-examine, you will say, no, this is the issue. But if we continue like this, we'll never finish. Where whenever the witness must answer, you stand up. Let us have the witness do the job. And she can only be assisted where it is necessary. But I don't think it's necessary now. We're talking about business, and you'll get time to deal with that in re-examination. And this court is listening anyway. I'm here. So I'm listening, and I will know what happened. I may not go back to everything, but the major issues I will be able to know. If we're talking about construction, and you want to call it property, we'll deal with it in re-examination. So let's proceed, Mr. Michel.
Thank you a lot. Doctor, just last week, the accused never told this court about him running the family businesses in Venda, which is what the information you have in your report. Are you able to comment on why we were not told about that?
I am not able to comment because I am also informed of the businesses in Venda.
Thank you. And you are also informed that he works from home.
Yes, sir.
Thank you. Let us go to page 9. Interview with Michelle Isaac. You see that?
Yes, sir.
I want us to go to the last paragraph on that page, where it says, when my mother told me.
Paragraph?
The very last paragraph of page 9. That will be paragraph 3 of the interview with Michelle Isaac. Proceed, Mama.
I just want to find that particular passage. It says paragraph that starts with?
When my mother told me.
Okay, yeah, I got it.
And doctor, this is your interview with Michelle.
Yes, sir.
And she says, when my mother told me that he is in jail. I got worried for my mother and the baby. The baby will be Rafaela, correct?
Yes, sir.
I asked you earlier about you testifying a number of times in the courts, correct?
Yes, sir.
I know, Doctor, and I don't expect you to know the cases, the case law. But I'm tempted, Doctor, to advise you that in one decided case of State versus M, and I just don't have the full citation with me now, but in State versus M, the judge said the interest of the children must equally be looked into with the other interests. In other words, they are not looked into in isolation. You, as I indicated, Doctor, you may not be aware of this case. But now, having informed you of what the judge in State versus M said, are you in any way able to comment, take into account this statement that Michelle is worried about the mother and Rafael?
You know, Mr. Michelle, yesterday I was sitting here, and indeed I've read a number of reports by psychologists on other aspects, maybe the same, more or less the same aspects as we are dealing with. But yesterday I was listening with a lot of interest, and I discovered what a layman I was in issues of psychology when she was actually going through the report. And that's why I kept on asking her certain questions to clarify. So I see you are referring her to case law. She's a lay person when it comes to the law, but because she deals with these things, maybe she...
Yes, she frequently deals with these things, my lord, and
yeah.
It might not be outside her ambit to comment on it.
Okay, thank you so much. Are you able to do that?
Yes, sir.
Yes.
I did not say much about Rameez's biological children because I did not consult with them.
Yes.
That's my reason.
And you'd agree with me, they also need to be factored in when the judge makes a final pronouncement.
Yes, sir.
Actually, she shouldn't be Rameez's children, it should be
The deceased children.
Fatima's children.
Yes.
Because we are talking about Nazrin's child now.
Yes, and you are not insinuating they don't belong to the accused.
Yes.
Thank you, ma'am. As long as you are at par on that.
Yes.
Right. Doctor, let us move to page 12.
What time did you start? You started about 11:30?
Yes.
Wow, time moves now.
Yes. So, Malad, maybe let me take a pause because I see it's already 1 o'clock. Let me take a pause and maybe let us for a moment address the issue of how we're going to move forward. I am of the view, my lord, that we can proceed to finish the evidence of the doctor, cross-examination and re-examination. And then as to how the matter should proceed after that, that is something we can discuss.
No,
My lord, we,
I'm not finishing this matter today. I would rather work even in the night.
let,
I'm
yes,
not coming here. I'm tired.
there's no water in the building one. We can't use the ablution facilities around here. That is one of the other problems we're
What are
facing.
you talking about? What are you talking about? I mean, no. You must finish this matter. I don't know what we can do.
Well, I equally do not know, my lord, but the reality is that we have been without water since, I think, yesterday we didn't have water.
Well, I went to my chambers. At least there was still some water. I don't know now.
Yes.
No. We must finish this matter today. I'm not coming back tomorrow.
Well,
I don't know.
then I'm in the court's hands, my lord, whether now we should now take lunch adjournment or we should proceed and so until when.
May I make a comment to this?
Yes.
My lord, I'm happy for us to proceed with the matter, subject to, of course, your lordship canvassing this with court staff, and if they're happy with it, then we must just proceed, because I understand exactly what your lordship said.
Yeah, otherwise, because today I must definitely go home.
That's another thing, my lord. Take into account what
Yeah.
we discussed
If I
yesterday.
have to come back, then I'll have to drive back tomorrow. I don't think I can put up here today. Besides, I'm not even booked for today, where I'm staying. So, you say?
That can be arranged.
Or yeah, okay, fine. Maybe what you said is correct. Let us pen this and then we'll discuss it.
After this witness.
Yeah,
Surely.
not necessarily after this witness. But what we can do now is to take lunch, a short lunch. Because we take a short lunch, we come back at what time do you think we should come back? Half past?
My lord, I'd be happy with 15 minutes, but if your lordship believes it should be 30 minutes, I'm in your lordship.
No, 30 minutes. 15 minutes is nothing. By the time I arrive in my chambers, I will have lost about 7 minutes. So maybe 30 minutes?
That is
Come
in
back?
order.
To 1:30 p.m.
1:30, yes.
1:30.
1:30, we come back and then we proceed with this witness. I hope she has got a lunch around. Because I'm not going to continue with a witness who's hungry. You would rather be hungry, yes, but not her. So, yeah, let's adjourn and then come back. I believe we'll finish in another 30 minutes.
Not in more than an hour. Well,
Hour.
30 minutes, an hour will be finished.
Yeah. Okay, it's all right. And then we come back and then you are doing the examination, which will be short, I believe. And then you are still going to address me in mitigation. We still going to do the same.
Yes.
Yeah.
Aggravation.
That's the yellow darkness. Yeah, it's, I don't know, I'll have to call my son and see what. Okay. All right, let's adjourn for 15 minutes.
All right.
Emily?
Cross-examination.
The children were still there, and I know they are still living with the father right now, despite all these other things that happened. But in this case, I only didn't want to interfere. Because I'm busy with the criminal case, I didn't want to jump into the children's issues. Only thing that I do, every time I would ask about the whereabouts of the children, they weren't there. But anyway, thank you very much for that.
Thank you. Thank you, ma'am. Doctor, I just want us to refer to this last paragraph on page 18. In this paragraph, you went on to, in the main, refer to the father and son relationship. Correct? The one that's that in the context of father-son attachment.
Now I see it.
Yes. In that paragraph, without reading the whole of it, it goes on into the context of the bond between the father and the son.
Yes, sir.
Now, having read this paragraph, are we able to factor in the mother in this relationship?
Yes, we are.
Is that possible?
It is.
And it still works according to it, will still function properly if we factor in the mother.
It will bring a balance.
Thank you. Now, I want us to quickly move, Doctor, to page 27. The back, 27. The report on the back depressive inventory, BDI2.
I'm there.
Michelle, of Michelle, you see that?
Yes, sir.
And I see on page 27, you give a score of 30, and in bold there, you say this indicates that on the day of assessment, the emotional function met the category of moderate level of depressive mood, which warrant immediate psychological intervention. You see that?
Yes, sir.
And I see, Doctor, this recommendation, you keep repeating it over a number of, as you go along, assessing the other kids, correct?
It's true.
Yes. So it won't help repeating on each and every kid. We can just simply deal with this one kid. It will cover the others.
Yes, sir.
Do I understand correct?
Yes, sir.
Now, this recommendation, I just want you to understand, Doctor, is there any intervention that can be injected to assist this particular child?
Yes,
to be able to cope with this condition you highlighted?
I recommend that all the children undergo psychotherapy to deal with the depressive mood and other emotional issues related as the result of Rameez being incarcerated. So
if we are to inject that psychotherapy, it will assist all the 4 children. Let's talk of the 4 children for now. All the 4 children of Rameez and Nazrin.
Yes, the prognosis is promising.
Thank you. the court can just bear with me, my lord. Yes, I indicated I have these questions repeatedly as I go along with the other children, but I shouldn't be dealing with that. Now, Doctor, let us sorry, let us go to page 35. On paragraph 9.3, you see that
Yes.
BDI on Nazim. You see that?
That will be Lazim.
Yes. Now, Doctor, I just want you to comment on your bullet 4, where he says, I blame myself all the time for my faults. This self-blameworthiness, is that an isolated?
Which bullet? Because I see Nazim's
At 9.3.
Nazim results, is that where you are?
Yes.
I feel I'm being punished, is that the one? No?
Oh, my lord.
I feel guilty, no?
At 9.3 it says Nazim results.
Yeah.
And then, okay, maybe let me clarify. Doctor, let us look at that paragraph. You see, it says Nazim results, but the sentence there speaks about Lazim. You see that?
Yes.
Is that a mistake? Is that a typo? What is the situation?
It is a typing error. I was referring to him as Nazim instead of Lazim.
Thank you. Does that clarify the court, my lord?
I think I'm at the wrong place. But I have Nazim in this.
May I assist at this stage, my little friend and the court? My instructions are that the name is really Nazim. There seems to be some confusion in the mind of the witness. It's not Lazim, it is N-A-Z-I-M.
It's Nazim.
Nazim, that is correct.
Okay.
Nazim. Yeah, I think yesterday I was saying, you were saying Nazim,
Yeah.
but you later changed to Nazim. Okay, that's fine.
Their name confuses me.
Yeah, they were confusing you throughout. Just like, you shouldn't be worried. Even culture themselves, they were mixing Razim with
Rameez.
Razim.
Rameez.
Rameez with Razim.
Mm.
So you shouldn't be worried. There was a mixture up, but we corrected them. We can proceed.
Yes.
That is page
Doctor,
87, 35.
yes, I want us to look at bullet 4.
Bullet 4,
Yes.
which starts with I have.
I blame myself all the time for my faults.
Oh yes, okay, yes.
Thank you. Doctor, this self-blameworthiness, is that an isolated condition, or is it a situation where more or less all the children will come to faced with this similar situation?
It is not an isolated incident. It's happening often with children and adolescents.
And with psychotherapy that you spoke about earlier, do they cope?
if psychotherapy go deeper to the roots of the self-blame, which in some cases it arises from the children perceiving the situations, the traumatic situation in the family to be their cause of that situation. If they go through and deal with it, they will be helped.
Thank you.
And I think yesterday you said children tend to blame themselves for the wrong of others.
And also to feel guilt.
To feel guilty.
Thank you, Doctor.
Yes.
And Doctor, on page 36, I see there on back anxiety inventory, BAI,
Yes,
you made your comments there.
yes, sir.
Down there on the score of 90.
Yes,
Am I correct to take it that with psychotherapy, this condition will also improve?
yes, you are right.
Thank you.
So do you say may and not will? It may improve and not will.
It may improve.
Okay.
Yes.
Oh, that's fine. Thanks.
And this recommendation we've spoken about already, the sentencing recommendations, correct?
Yes, sir.
The one at page 40. I'm about to wrap up, my lord. I just want to make sure I don't miss anything.
Yes.
Doctor, did I understand you correctly when you testified yesterday? Oh, I'm off the report, doctor. You can now show.
No, okay.
Thank you. Did I understand your evidence yesterday to be saying on your first meeting with Nazrin, the message from the receptionist was that a mother called and asked if I could assist in a custody battle?
Yes.
And you, after agreeing to meet the person whom you later got to know as Nazrin, your interaction with her didn't dwell much on the custody battle, as you were informed.
We didn't even entertain custody at all.
So, contrary to what you were informed that will be the subject of the discussion, you got now to discuss the issue of the accused.
Yes, sir.
Thank you. Thank you, Manot. I've got no further questions, and I truly appreciate your assistance, Doctor.
Thank you so much. In re-examination.
Thank you, madam. Doctor, let's take the last question first.
my learned friend questioned you on what your receptionist had conveyed to you in relation to what Ms. Nasreen Myers had come to see you. Is that correct?
Yes, sir.
So this was the understanding of your receptionist, that she had come to see you in connection with a custody matter. Is that correct?
Yes, sir.
Yes.
Doctor, please correct me if I've misunderstood this, but this point is in need of clarification. You're not saying that Ms. Nasreen Meyer misinformed your receptionist what she was there to see you about, are you?
I am not saying she misinformed my receptionist. I am saying my receptionist thought she's coming to see me concerning a custody matter.
Thank you, Doctor. Doctor, your report and recommendations are founded on the facts which you encountered during the course of your consultation with the various people you referred to there.
Is that
correct?
not a leading question?
No, my lord, as I understand it, that is something obvious, but should your lordship desire...
No, that's fine, because yeah, we're in mitigation, and maybe that is allowed. You can ask for leading questions. So be it.
But my lord,
She's an expert anyway.
thank you.
Yeah.
Thank you. So, doctor, and this was your evidence that you interviewed these various different people, is that correct?
Yes, sir.
You have recommendations which you've made in relation to what you consider to be an appropriate sentence under the circumstances. You've given options as you've indicated. And what are these based on, those recommendations of yours?
My recommendations are based firstly on the information I was provided with during the interview with several family members that I had a clinical interview and assessment with. Secondly, based on the psychological damage that might happen or impact on the children, especially the minor children, in the absence of one of their parents.
And in this case, what was your focus on which of the parents?
My focus was on the father figure to the children.
Doctor, may I take you to what was put to you by my learned friend relating to the gender-based violence scourge, and he also made reference to you of the increase in matters such as murder. Didn't say it specifically, but he said that this is a scourge to society, this type of occurrence, and he then qualified it by saying gender-based violence. Do you recall that?
Yes, I do.
Now I want you to tell this court what your main aim and goal is in having conducted your investigations and in having furnished your reports and your evidence, vis-a-vis continuing incarceration of the father, namely the accused in this case?
My main aim when I was conducting and writing the report was to show the court the psychological impact of the absence of the father in the minor children. And my recommendations are based on the information that was available to me at the time of conducting the assessment.
Doctor, you also made reference to having performed various different tests. Is that correct?
Yes, sir.
And please indicate to this honorable court your confidence in those tests producing an accurate result.
I conducted a set of objective personality assessment. These are psychological assessments that measure the individual personality traits, their characteristics, and behavior. They are non-structured and unbiased in nature. Therefore, it is not easy for the patient or the client to fake or to malinger. And I also conducted self-report questionnaires. These are a quick way of assessing data related to the client feelings, thoughts, and experiences. So I believe the assessment that I conducted, they are not easy to mislead us.
And doctor, to what extent were these tests which you applied case specific?
Repeat yourself, sir.
To what extent were the tests that you performed, these various different tests, to what extent were they case specific? In other words, specific to the needs and requirements of those children whom you subjected to these tests?
If I hear and understand you well, I will answer in this manner. When I chose those tests, I wanted to find out how the children are coping with the incarceration of their father and possible behavior challenges and also their thought processes.
Doctor, please go to paragraph 1.3 of your report. This involves a matter on which you were cross-examined by my learned friend. And you will recall, Doctor, you said that it might be necessary for you to review your report, words to that effect. Do you recall that?
Yes, sir.
And I understand the context in which you made that statement. In other words, that was when my learned friend put to you, in view of the fact that you now know a factor which you said you were not aware of initially, how would that impact on your report? And your response was, well, now that I know this particular factor, I may have to review my report. Do you recall words to that effect?
Yes, sir.
Well, which means if you knew that information, you had that information at your disposal, at the time you conducted your test, it would not be necessary for you to review it. Am I right in understanding that? We just need clarity on that. If you knew it already, if you had those facts, you had everything, would it still be necessary to review it?
No.
It would not be. Right. Now, let's go to paragraph 1.3 and look at the last sentence in paragraph 1.3. That is at page 5 of your report, Doctor. Will you please read that sentence into the record?
It says, on the 25th November He was found, referring to Rameez, guilty of the murder of his deceased wife, Fatima.
So you were aware of this at the time you wrote the report and formulated your views, is that correct?
Yes, I was aware of that he's
He was
found guilty.
Yes. We understand that it's not an easy thing testifying
Mhm.
in a court which is as highly qualified as this, with as experienced a judge as His Lordship Mr. Justice Raudenga. So one does get a little intimidated, and sometimes it's necessary to rethink, you follow. So, you know, when you gave your evidence earlier on, I think you said you were aware he was accused, but you're not aware that he was found guilty, just to refresh your memory.
Okay, sir. Thank you.
But let's proceed further. You recall my learned friend questioned you on the sentence in paragraph 1.3. Intimate relationship between Rameez and Nasreen only started 2 years after the passing of Fatima. That's at paragraph 1.3, page 5. That's the same page and the same paragraph.
Yes,
You see
sir.
that?
I'm there.
So this sentence on which he questioned you is that the intimate relationship between Rameez and Nasreen only started 2 years after the passing of Fatima. You recall this?
Yes, I do.
What he put to you was that there was a gentleman by the name of Ishaq who gave evidence which he suggested was to the contrary. And you said, well, you don't know about this. You remember this?
Yes, I do.
Now my question to you is this.
Mm.
Is that aspect, that the intimate relationship between Rameez and Nasreen only started 2 years after the passing of Fatima, is that relevant to your assessment of how long-term imprisonment of the accused will impact on his dependent children, whom you refer to in this report?
It is relevant because I asked this question to understand the depth of their relationship.
Now, let's go please to page 7, paragraph 3. And that deals with the impact of the separation. And you've detailed this in your report very well. The doctor, my learned friend asked you about, on several occasions, the effect and impact of psychotherapy on what you indicated are the conditions that these minor children will experience and encounter as a result of any long-term incarceration of the accused. Do you recall that?
Yes, sir.
Now, the question which I'm putting you for the purpose of clarity and for the assistance of the Honourable Court is this. Psychotherapy is intended to assist and in appropriate circumstances cure. But when you balance that out against continuing incarceration of the accused, so here you have the children presenting with negative symptoms, and there's psychotherapy administered, but the negative factor which culminated in the causes necessitating psychotherapy still prevails. In other words, the father, the accused, is still in long-term incarceration. How will that impact on the possibility or prospect of psychotherapy curing the condition? Like, for example, the one minor child says, I feel like killing myself. And others said, we don't want to associate with anyone, etc., etc. Do you understand?
Yes, I do. I will repeat myself that psychotherapy, when the trauma is prevailing, it will bring a balance and management to some extent. However, we might not expect a cure, therefore the prognosis is guarded.
And, doctor, when a child says, I have thought of taking my life, when a child says that, what should be the reaction of the psychologist who hears this, and the reaction of all others, including his lordship, who sits as the upper guardian of minor children? What should be their reaction to a statement of that nature?
Thoughts of suicide should be taken with precaution, because we are not sure what will trigger him from thinking of committing suicide. Right now he says, I am not planning to do it, but we don't know what might happen tomorrow, and he might do it. So I will say there is a need for immediate psychological intervention.
And in keeping with what you said earlier on, that psychological intervention or psychotherapy may have limited effect. In that context, how important are your recommendations relating to the sentence that should be imposed?
I said the prognosis of the children is guarded, and I will say, as the court rule, I recommend that they look into the mental health of the children and their future.
And insofar as the sentences you recommend are concerned, how important is that in order to preserve the life and the psychological integrity of minor children, of these minor children?
It is of paramount importance that the court, as they rule, they consider the well-being of the children. Whatever sentence that the court give, if they consider the mental health of the children, it will be in the interest and the benefit of the children.
Doctor, please go to page 8. These are the pages which my learned friend refers you to, and paragraph 4. Do you recall my learned friend put to you certain matters, and you said you had no knowledge of this, you simply applied what you were told, and he said something about vendor. Do you
Yes,
recall that?
yes, I do.
And he read out a paragraph from the bail application,
Yes,
which
sir.
made reference specifically, save for vendor, where the accused said there's some business interest, all his other business interests are located in Polokwane. This is what my learned friend put to you. Do you recall that?
Allow me to answer in this manner.
Yes.
The mentioning of businesses in vendor, I got it from Nazreen, not from the accused.
Yes.
Yes, sir.
But insofar as business in vendor is concerned, some reference was made to some business or business interest, as I understand it, in vendor. Is that correct?
Yes, sir.
So whether that is a business in construction, or whether it is a business in the development of properties, or whether it is a very big development or a very small development, would that impact on your